Okay, it's 1 minute after 12, so I am going to get started. Try to keep us on time. So, welcome to another installment of webinars for busy lawyers, Mindful Client Selection, Balancing Service with Boundaries. We're excited to have you join us for today's webinar presented by attorney Luz Carrion. She is the Senior Law Practice Advisor here at LCL. My name is Amy Levine, the Director of Programs and Volunteers at Lawyers Concerned for Lawyers. I will be your host today, and I'm going to introduce Luz momentarily. First, if you're joining us for the first time, Lawyers Concerned for Lawyers offers one-on-one consultations with licensed clinicians on mental health, substance use disorders, and well-being. Additionally, we provide educational programming, support groups, and one-on-one consultations on law practice management for the Massachusetts legal community. Our services are confidential and free. Now, I am honored to present our speaker. Prior to joining LCL, Luz was an investigator and assistant bar counsel at the Office of Bar Counsel of the Massachusetts Board of Bar Overseers. She was previously served as complaint counsel at the Massachusetts Board of Registration in Medicine. She is an expert in ethical, regulatory, and practice issues affecting those professionals. Luz also clerked for the Massachusetts Juvenile Court after earning her JD from New England Law in Boston. And at LCL, she does one-on-one consultations on law practice management, writes articles, speaks regularly at bar associations, the MCLE, law firms, and other legal entities. For more details on Luz's background and expertise, I encourage you to review her full bio on our website. Finally, we love and encourage questions. Luz will answer those at the end of our presentation, so please use either the chat or the Q&A functions for that. Now let's get started, and Luz, take it away.
Thank you so much, Amy. You're too kind with that introduction. So let me share my screen so that we can get started. And Amy, please can you see? It says that the participants can see.
Yes.
Okay,
Looks
beautiful. Thank you so much, and welcome to this installment of Webinars for Busy Lawyers. Today, we're going to be talking about mindful client selection, balancing service with boundaries. And before we get started, I want to spend just a couple of minutes on reflecting, and I invite you to join me in this reflection on service and what does service means to you and to lawyers in our community. So think about, the values that come with service. What do you cherish and honor with that service as a lawyer? And how does it feel when you embrace this value or notion or goal or aspiration of service as a lawyer? I can tell you a little bit about myself that I was a government lawyer, and being a public servant is part of my identity, it's part of who I am. And I do honor servicing the public, lawyers, when I was in practice, servicing the organization, again, the public, as a state or a government attorney, and protecting the public as well. So I invite you to think about service as we navigate today's webinar. And also, we're going to talk about boundaries. My screen is not, oh, there you go. Today, we are going to focus on recognizing the early signs when we of some concerns with clients. So we're going to focus today also on the intake part and the client selection during the intake process. We're not going to deal with the current difficult client and whether you have to withdraw or terminate representation. We're talking about the early client selection process when you are interviewing, let's say, a prospective client. We're going to focus on recognizing early signs, understanding your emotional responses. This is very, very important. How to set and communicate boundaries, and how to decline representation ethically and compassionately. Why client selection matters? It matters for at least 4 reasons that we have here. It avoids compassion fatigue and burnout. We are seeing more and more of that in our profession. Similarly, reducing the emotional toll from misaligned matters. Of course, very important, upholding ethical and professional standards and preventing repeated training scenarios. And we can also talk about the financial consequences of doing a poor client selection process. Today, we're going to focus on 4 areas when selecting clients. We're going to talk about the fit with your legal competence, your practice capacity, and other ethical issues. We're going to talk about collaboration and communication between you and that client, the clarity of goals and process throughout the representation, and very important, as I stated before, your emotional response. We're going to do or take an approach that I think it's very useful, and we're going to do a traffic light framework. And if you see in this slide, there's the traffic light, but then we have the colors inverted, and there's a reason for that. The reason is that the green or the green light are the ones that are mostly aligned with you, and those are easy to identify. If it's a green light, we're continuing. If we are facing a yellow sign or a yellow light, that's where you're going to spend some time. And that's how we're framing the conversation today. The red light, you're going to spend some time as well, but some of them are very obvious from the beginning, and it's going to be red, and you have to stop. Also, just to clarify, the slides, which you will be getting after the webinar, refers to a client, but to try to condense the information in the slides, the client, for purposes of this webinar, means a prospective client, a current client with a new matter, or a former client that returns to your office with a new matter. So let's dive into the first area of focus when we are engaging in client selection. Fit with legal competence, practice, capacity, and other ethical issues. Let's start with your ethical obligations and the rules of professional conduct, because if there's something under the rules that prevents you from taking on that client, that's a red light. So you have to stop. So it's best to address these considerations first, rather than spending too much time with the prospective client or the client and then find out that there's some ethical issue that will prevent you from taking on that representation. So let's go through this. First and foremost, are you competent? Okay. If you're competent, for that matter, that's a green light, easy. If you're not competent, then we have to do a pause and clarify for the yellow light. And for example, is this something that you can get up to speed and become competent? Many times we can, sometimes we cannot. And if you're not competent, that's a red light. Like I said, you need to stop and not take the case and refer this matter out perhaps to another attorney. Do you have the time and resources to give this matter the appropriate attention? And this is diligence 1.3, right? If you're overloaded with clients and cases, can you take on another case? One thing that is important, because not a lot of attorneys are aware of comment 1 on Rule 1.16, and it's, can I complete the case? So, for example, if you're planning for retirement and you're retiring in 3 months, and a new client comes in and the matter takes a year to complete, you should not take that case because you know that you're not going to complete it, right? And most importantly here, there are no conflict of interest. Moving on with the rules, if the representation will involve a violation of any of the rules, that's a red light, right? You need to stop. Also, if you have a physical or mental condition that materially impairs, and look at the material element of this rule. It has to materially impair your ability to represent the client. Again, red light. If you have questions, then it will be a yellow light. If not, you're good to go with a green light. I wanted to pause here and let you know of a new change that is coming up next month on Rule 1.16. And there's some history with some federal legislation and the ABA and ABA opinion. We don't have time to cover that, but it is good for you to know that as of June 1st, you have to make sure that your client is not seeking to use or is persisting in using your services to commit or further a crime or a fraud, even after you have had the required discussions under other rules. That's a new requirement that is coming up next month. And that will be a red light. The client's claims are not frivolous. Unfortunately, sometimes a client or prospective client will come and they have suffered some injury or damage, or they think they have, or the case, you can't prove all the elements of a case. If you know you can't prove the case and there is no case, we all know it's frivolous. You can't take it. It is important that you also pay attention to your role as advisor under the rules. And that to be an advisor and a counselor means that you can exercise independent professional judgment and render candid advice. So similarly, you're sure that you can maintain professional boundaries with the client, and the client has some realistic expectations about what's going to happen or could happen. We're moving on now to the next area of focus, which is communication and collaboration. And this is to mean that collaboration and communication between you and the client. And in this area, there's some things that I want you to consider. One, how your client communicates with you in terms of telling you what happened, okay? And also that the client, when he or she is communicating with you, it allows for that mutual understanding or appears willing to work toward a shared clarity with appropriate support. Sometimes the reality is that we get prospective clients or clients that are traumatized because of the legal issue that they're facing, or they have past trauma, they might be disabled, they might have mental conditions, and so on. And so you have to pay attention whether that client can communicate with you, or the client needs some help or guidance, in the way, for example, you can ask more focused questions and narrower questions during the client intake, but pay attention how the client is communicating. And so the yellow light here is to, trying to discern and be aware of possible traumas or disabilities that might impair at that moment in time how the client is communicating. If the client is open to legal guidance, sometimes we encounter clients who just have this fixed mindset that this is how the case should proceed, and this is what I want to be done. Might not be the best or course of action. And so this could be a yellow light to see that whether this client, is amenable to see other options, and maybe the client is open to explore the holes, for lack of a better term, on their case, or the weaknesses on their case. Also, this is very important, the last one, that could be also a yellow light or a red light, as well as the other two. Can the client engage within professional boundaries, or is responsive when those boundaries are gently clarified? And you can tell this early on. For example, when the client is trying to schedule the initial consult or call with you, pay attention to that behavior. And also, if it's green, like I said, that's easy. But if there's some difficulties, then you have to assess, yellow, first of all, caution. You're going to pause and clarify, and then you will decide, is this a green light or a red light? Similarly, and I said this a little bit before, how the client tells their story. You have to take into account, again, some factors that might impair their ability to tell the story. But the question really is, can you work with that? And is the client willing to engage in that process of working with you? That's super important. Another issue here, you might see that there are some things, client is perfect, right? Sometimes we have to work with our clients a little bit more, and we can do that, and that's okay. But do you have that patience to, spend a little bit more time with this particular client? And it's something that you can work with, right? So again, once you have done that pause and clarifying that, then you go to the green light or the red light. Moving on to the next area, clarity of goals and process. Again, these are things that you can tell early on. For example, when the client is expressing their concerns or the outcomes, what they want to see. Of course, they want to see justice. They're seeking justice, right? But what does that look like? What does that justice look like? So that's something that you need to explore a little bit during the intake process and that initial interview. So if the client appears open to some of your support in clarifying the goals, if at that time, like I said, if they're just going through a traumatic event, they can see it now, but you can see that there's some openness and willingness to, what, I can explore this once I, come out of this crisis or things, settle down a little bit for me. Does the client tolerate the pace of the legal process? These cases could take years. Take, for example, the immigration cases, some criminal cases, and some civil cases. The cases could take years. Does the client understand that sometimes the process is slow? And so, for example, from my experience at the Office of the Bar Council, this was something that, again, some clients were not able to see or understand that sometimes there's a backlog in the court, and some things might take longer than expected. And so they would call frustrated to the intake unit and say, my client, my attorney is neglecting the case, or this is moving too slow, he's not paying attention, or she's not paying attention to the case. And when you go, so one of the things that I would do with complainants was, let's look at the docket, right? And this is something that you can do with your client as well. So if the case is in litigation, so I would go to mass courts and say, okay, so let's look, and I would often see that there was a lot of activity in the case. So the attorney was working on the case, but there were some delays because they were waiting for, an order from the judge or something else that was beyond their control. And me having those conversations with the clients often help them realize, oh, you know what? My attorney is working on the case. This is something that is beyond his or her control. You should have those conversations as well. But if the attorney if the client at the beginning is, telling you like, we need to resolve this in a month and it's not realistic, pause and then decide whether you're gonna go or stop. Continuing with our area of clarity of goals and process, we have here, again, that willingness to engage in a respectful conversation about fees. This is super important. We're going to talk about fees later on, but at the beginning, if this potential prospective client or client is not willing to discuss fees or have even that respectful dialogue about fees, that is more towards the red light, right? Because those are often the things that, as the case continues, will keep coming up as an issue. Every time you send that bill or that invoice, they're likely to question everything in the invoice. They're likely to file a complaint or engage in a fee dispute. So this one, you really have to slow down and try to find out, why. Why is the person not willing to engage in this respectful conversation? It might be a red light, and that might be, something that you're going to say, no, this is not a good fit for me. We're not clear on the goals in the process, particularly the process, right? And as you're talking to the client and you're thinking about your fee agreement, that you're like, okay, you know what? I can envision the scope of work that I can do to solve that legal issue or problem. And, maybe if I can work a little bit more with this client, and we can, pivot accordingly, I think I can see, some sort of pathway to resolve this case. But the key thing here is that, you can see the scope of the work that you can do to accomplish resolution, right? Finally, I want to talk about your emotional response. This is super important because what I've seen both when I was working at the Office of the Bar Council and here at LCL is that a lot of attorneys who encounter whether a client complaint, whether to the BPO or their, the firm, a lot of attorneys end up telling me, I should have listened to my instinct. I should have listened to my gut. I knew it from the beginning that, there were all these warning signs, right? And I ignore my gut feeling. It happens. And so that's where you need to, pause and clarify. That yellow light is super important. So let's go through some of the questions that you can ask yourself. Do you feel grounded and professionally clear or emotionally entangled? So if you're gravitating to all the emotions that are going on and you cannot be objective or clear, that's a warning sign. Are you motivated by sound legal judgment or by guilt, urgency, or desire to rescue? This happens. This happens a lot in our profession because we're grounded in service. And a lot of us take service very seriously. We want to serve the client and help the client resolve that legal issue or problem. And So you have to pay attention to that urge. So it's not just service. If you're feeling that you're trying to rescue someone or fixing someone, you have to pay attention to that because it could become a problem later on. Can you imagine setting limits, right? Or is this a client that you're like, you know what, I don't know how I'm going to say no to this client, or how am I going to set boundaries with the client? Pay attention to that, because if you can't handle that client during the intake process, chances are you're not going to be able to handle that client during the case. Finally, but this is super important, is your client's distress activating something in you that would cloud your objectivity. Remember what I said earlier about you having independent professional judgment, okay, and being objective and being able to provide candid advice. Now that we have covered the 4 areas, I'm going to spend some time, just a few minutes, on some warnings. And if you see in this line, there's no green light, okay? Because if you see this, it's going to be a yellow light, and most of the time it's a red light, okay? So let's focus on this. When the client has multiple prior attorneys, that's a warning, right? So you want to inquire, how many attorneys have you consulted prior to talking to me? How many attorneys represented you in this case? Pay attention to that. If the client also is unclear on their financial commitment, avoiding to discuss fees and so on, again, pay attention. When the prospective client or the client comes in with a friend or a family member who wants to take over the representation and tell you what to do, and most of the time that person is also paying the bill, you have to be careful, because it can be done. A parent can pay the legal fees for a child who's encountering, let's say, a criminal case. But you have to be clear on this. And just remember that under Rule 5.4C, that person can pay the fee, but they cannot direct the course of the case. Okay, you are the attorney, and the client is the client, and the client decides. You're not gonna follow the family member or the friend's quote unquote advice. So that needs to be clarified early on. Number one, if you're gonna pursue that. But pay also attention to how much that person, that friend or the family member, is pressuring you and the client, because sometimes that friend and family member most likely is going to end up filing a complaint against you, and they're not even the client. Last minute request. It could happen the first time, it could happen only once, that it just so happens that there's an approaching deadline and the client comes last minute. But pay attention if they keep doing that over and over, and you can inquire about this also. If they're not compliant, so pay attention at the beginning. If you tell them, hey, I need you to bring this document, that document, and the other, so that I can review them and see whether I can take your case. And if they don't follow that specific and simple instruction, pay attention to that. Because if the client is non-compliant, they don't follow instructions, it's going to be very difficult. Other behaviors that some clients may display, they are here. I'm running out of time. I want to spend some time on representing friends and family members. These are the common pitfalls, and be very careful about representing friends and family members, because they will file a complaint against you. So what often happens is that because it's a friend or family member, you let your guard down. So you don't have a fee agreement. You're not billing regularly. You're neglecting the matter because they're like, hey, they understand that I'm busy. You're not competent in the matter. Also, sometimes there is a misunderstanding. You have a friend or family member coming, hey, I have this question. And, you continue talking to that family member or friend about that question, and somehow they have the impression that you're representing them, and you're not, right? You don't have that intent. And also sometimes there are conflicts. So you may talk to a couple of family members, for example, and you're trying to help them resolve something, and somehow you end up, being the attorney for two people who have adverse interests. There are some respectful ways to decline a client if you decide to say, if there are too many red lights in some things. Let's assume that everything on the ethics side, is good to go, but you have a lot of red and yellow. You have to think about, am I going to take this client? And you can, tell the client, first of all, affirm the client's dignity, because our clients are complex. It's not something pretty straightforward. They come with a lot of issues, personal, emotional, health-wise. So we need to treat those prospective clients with dignity, and something as simple as saying, "I appreciate you sharing your story with me." That goes a long way. Even if you don't take the case, just treating that prospective client with dignity, it might be that client or that prospective client ends up referring someone else to you, and that case might work out for you. And then try to keep it professional and neutral. Always send declination letters, because the more difficult the prospective client is, and the more volatile the situation is, there could be a lot of misunderstandings. You're not, they might have a different perspective or perception of what happened. Always send declination letters. How do we set and communicate boundaries? There's 3 important and simple steps that involve writing it down and documenting. The fee agreement, be clear on the fee agreement. A communication policy, I really recommend those to our attorneys, especially depending on the area that they practice and their client population. You can have the communication policy within your fee agreement, or have something more comprehensive as a separate document. And, you can schedule a consult with me, and we can talk about ways to implement a communication policy. One piece of advice that I give attorneys: if you're going to set up this, don't just email it to all your clients or send it via regular mail. Have a one-on-one brief conversation with the client and explain the policy. This is what we're doing from now on, right? It's never too late to set up a communication policy, but you need to explain it to them. Don't just, cold send the policy. When you have the third party involved, put it in writing, okay? And inform the client, listen, you need to waive confidentiality. If they come in, talk about confidentiality, right? Explain who the client is and who makes the decisions. Get waivers. And that's it. Thank you so much for your time. Feel free to schedule a consult. You can click here or check our website. And I will stop at this point because I see some questions and I want to address those.
So, Luz, this was an amazing presentation. And there are a couple of issues. Is that one, you need to think about your own experience and mental health in responding to a client, but also the ethical side, where not all clients are going to be good clients, and you have to be aware of it and think and be thoughtful about it. So we do have some questions also related to some of the things that you talked about. So I want to address those. And this was similar to what you started talking about if a family member approaches you. Do you have any advice for when a sibling asks you, to help them out and take on their legal case pro bono?
Yes. Yes. So let's talk about that. It often happens. And you have to think about the relationship, right? Because what often happens is that the attorneys will say yes, and take the case, even if it's paid or not, if it's, with a family member, especially a close family member, like a sibling. And when you then take on the case, and especially if it's pro bono, and the case involves a lot of time and complexity, you're gonna be stuck with that pro bono case. And what attorneys tend to do is that then they resent that decision, and then they neglect the case, they avoid the case. Something goes wrong in the case. Often the sibling, I'm telling you, they will file a complaint. And so in those situations, what you have is that now that relationship is damaged and sometimes broken. So my advice is to kindly, tell the sibling that, you cannot, take it, because it will be, a financial burden in your practice. And be, and again, you can talk to them and it's, explain as much or as little as you want, but have the conversation, explain that you cannot, check, your practice if you're too busy, right? Um, that, taking on that case might hurt your practice in managing your caseload. Also, you may be going through some, financial difficulties in your practice. People assume, especially family members and friends, that because you're a lawyer, you're loaded with money. And you know what? And yeah, you can take a pro bono case because you have tons of money, and that's not the reality, right? You have to pay the bills in your practice. Um, and so it's not financially feasible. And so yes, I would say have the conversation and explain those things, um, depending on how your relationship is with the sibling.
So one of the things I wanted to also mention, and this is somebody made a comment that I think your examples of having to have a conversation, of having that conversation and saying no in a kind way, in a gracious way. You don't have to be mean about it. You don't have to be. That could clearly start more difficulties and trouble. So somebody again mentions it that they really appreciate the suggestions for graciously saying no.
Yes.
Somebody else also commented, helpful presentation, particularly affirming that it's not only okay, but likely the correct path to decline to accept a client. So
Mm-hmm.
thank you for that. We do have a couple more questions, so I do want to get to those.
Mm-hmm.
How do you manage through this initial interview discussion tree when a client experienced trauma and that's causing the issue in clarity, or even the client clams up and resists talking about the hard facts until they know they have secured representation?
That's a great question because that happens a lot. So
Mm-hmm.
thank you for that question. And my response would be, um, the client might be experiencing that at the moment, that they don't have that clarity, and they're, they clam up and have resistance. So be curious. I would say be curious to see whether this is something that is now happening because it's a normal response to trauma. Okay. But see if there are opportunities where, for example, if you present an alternative course of action, for example, if they see things, they think that they have a case and they don't, for example, explaining to them and see what's their willingness. On the other hand, let's say that they do have a case and they're saying, okay, I might be able to work with this person, even though the person is experiencing trauma. Try to engage in conversation, and again, let curiosity be the guide. Um, tell me more about this. Have you considered this? What about that? And try to engage in that dialogue. Don't judge, but what you're trying to do is trying to get some feedback and data, information to see whether you can manage this client and whether, like I said earlier, is there a willingness or an openness to say, you know what, right now I'm going through a lot, I can't think clearly, but I think that, if you give me a couple of weeks, I can, regroup, for lack of a better term, and I want to explore this with you. I can't explore it now, but I want to explore, what you're suggesting. I would like to engage you. If you see things like that there's a willingness to move past that crisis mode, then that's something that, you have to consider. Maybe I can work with this person. But let curiosity guide you. Be compassionate and see if there's that openness and willingness to work with you, to help you out, right?
So themes coming through: compassion and empathy, whether it's trying to gather more information or having that difficult conversation. So those are some really important takeaways. So somebody else asked, a conservator is not providing information needed for court filings that were due 6 months ago, is not returning the phone calls, and has not paid this person's legal services statements. Should they now file a motion to withdraw? And may they file a copy of the legal services statements with their motion?
So first of all, I cannot give you legal advice, but this is what I'm going to say. Look at Rule 1.16 on when can you withdraw from a case. There's different factors that go into this, right? Because, first of all, you have to file a motion, and it's up to the judge to decide whether you're staying in the case or you can withdraw. You can't. So that's number one. Number two, you have to pay attention to Rule 1.6 on confidentiality. When you are going through that process of a motion to withdraw, if you less is more. Let me put it that simple. Less is more, because if you start divulging client confidences, you can get in trouble. And attorneys have gotten in trouble when they put a litany of private confidential information in their motions to withdraw. You have to be very careful. Something as simple as, there's a breakdown in the relationship. It cannot be repaired, right? And that's it. The more you're putting into the motion, the higher the risk that you are going to be divulging confidential information. So based on the question, when they say they're non-compliant, we talk about non-compliant clients, right? Not paying the bills, the legal services or invoices, that's you can withdraw, but a couple of things. One, it's up to the judge, and if they can, depending on the factors that are going on or the circumstances of the case, the judge might say, no, you're on the hook, even if the client is not paying you. So less is more. Follow those rules.
Great answer. Very difficult situation. Quite challenging. Next person asks, when initially reviewing a client and their case for acceptance, how do you balance the reality that saying no is right for you, but it's because there are language barriers, disability barriers? Isn't that discriminatory? How do you send people away who genuinely need help and you have the competence, but who will be a lot for you?
Yeah, so this is a good question. Okay, so let's put some things on the table, right? If you're saying, I can't take this client because they don't speak English, you can see that in two ways. One, competency, like you don't have a translator in your office, you don't speak the language, how are you going to communicate? So you're not competent to take that matter. That's one. If you're saying they don't speak the language, and I don't want to represent them because they are, they speak Chinese and they're, from China, or they speak, Cape Verdean and they're from Cape Verde, and they're Black. That's discrimination, right? But if you're saying, like, for example, there's attorneys, I've seen attorneys who say, I have the staff that can help me out with servicing Spanish-speaking clients, but I don't have staff to service Portuguese clients or Cape Verdean clients.
Mm-hmm.
That's what you have now. Maybe perhaps as you grow, maybe you can, incorporate more staff to address other client populations. So that's number one. Um, Disabilities. So it depends on disabilities. Can you work, with that disabled client? And so there's a few things you might to consider. So it could be in the grand scheme of things, when you look at the big picture in your practice, you might be able to deal with one client, this particular client, let's say, who is disabled, but can you take on then 5 more clients who are disabled? Maybe you can handle one, but not, 5 or 6. So that's something that you have to think about. And this is a yellow light where you're going to have to pause and clarify, okay, so what's the disability? Can I service this client competently and
Mm-hmm.
properly? Because that's what you need to do. Or if you're, on the other hand, your reason is that, you know what, I don't deal with disabled clients, or there's some discriminatory animus behind it. Yeah, of course it's discrimination, and so we shouldn't be doing that. But if you cannot help that person, you're doing that person a disservice. If your practice and you're not able to represent that client competently with what they bring to your practice. So how do you send people away who they need help? Again, we were talking about treating the person with dignity, right? So one of the things that you can do is say, listen, cannot represent you, but here's the number for the Mass Bar Association Lawyer Referral Service. You can call them and see if they have attorneys who can represent you. Here's a list of legal aid clinics that, depending on the income on the client, but, give them referrals.
Mm-hmm.
So if you can't help them, if you're able and it's appropriate to give a referral, say, hey, listen, there's a clinic in a law school who might be able to help you, right? So I can't help you, but hey, check this out and maybe they can help you, right? And it's just treating that person with dignity and respect. And I think in that question, again, and even if you have the confidence, but it will be a lot for you. So if it's gonna be a lot for you, it's best to say no at the beginning, because I'm gonna say it one more time. What often happens is that you ignore your gut feeling that, you know what, this is too much. And then when things get difficult, we tend to avoid those difficult clients. We tend to avoid those difficult interactions. You neglect the case, and then things often get out of control. So you're doing a disservice to yourself and to the client. So, saying no with respect and dignity towards that prospective client goes a long way, and there's nothing wrong with that. And like I said, we're balancing service with boundaries, and boundaries are good. Okay, don't feel ashamed or guilty because you're setting some boundaries.
Excellent. Again, themes: protecting yourself and being kind, saying no with kindness and empathy. So I think this is related to a person who asked about the conservator. Is there a way to get a court order for the conservator to pay for the services? That might be very specific and
That's
can't
too
answer.
specific, case specific. I cannot answer that. I'm sorry.
Okay. Earlier you mentioned, Luz, about frivolous law cases. And I would imagine that's a very gray area. What is frivolous? So is there a way that you could maybe clarify a little bit more? One question that comes to mind: if you're a personal injury attorney, this actually is not related to that, but if you're a personal injury attorney, and maybe you're used to $1 million cases and above, and somebody comes to you with a very legitimate case, but maybe the money isn't there in terms of what you're used to. How is that in terms of saying no to a client? Are there any ethical issues there?
One of the things that you have to consider is so how much the case is worth. And now we're looking, we're stepping back and we're looking at the merits of the case. We're looking at damages in the personal injury case. If it's going to cost the attorney more money to prosecute the case or to try the case or resolve, take on the case than the amount of damages that they're going to be able to resolve, it's okay to say no because you're not, you're hitting a loss. And, some of these cases are contingency fee cases. So that's more of the business side of it.
Mm-hmm.
Okay. If it's not frivolous, then, it's ethical to go forward. But the reality, and this happens again, it happens fairly often, that, it's not worth going after that case. If you're not going to recover, if you're going to recover like very little and it's not commensurate with the time that you have to spend on the case.
Also, earlier somebody raised their hand, and unfortunately, in the format that we have, we're not able to have somebody speak directly. So, for that person who did raise their hand, if you can put it in the Q&A or the chat feature, that would be great. Perhaps you did, so thank you for that. Another question. How do you maintain a positive attorney-client relationship when a client insists on trying to pursue additional claims that you've already declined because they do not have merit, but are already representing them in another matter?
That's a really good question. I mean, these are good questions. Okay. Again, that takes a little bit of, client management. Okay. And just, respectfully saying, listen, sometimes it's explaining like the elements of a case in not with legalese, but so that a lay person could understand, hey, in order for me to prove this, I need evidence of this, that, and the other thing. Okay, this is what I have right now. This is what you have. That is not going to prove this element, and here's why. And or we can meet two elements. We have that evidence for meeting two elements of the action, but the third one, I'm sorry, we can't prove that, and we need to prove all three, right? It can't be 2 out of 3. You have to prove all 3, right? And just having those conversations. I know that I had them with complainants who would call the BBO. They would just not understand, like, and that's normal. They're not lawyers, and they're being wrong, and they want justice. They're seeking justice. So when you look at it from that point of view and treat that client with compassion and spend a little bit of time, sometimes it's good to follow up with an email and putting things in writing. Sometimes that works. Sometimes doing, sitting down with the client and doing like diagrams, that works too. If they get like a visual picture, like a drawing, that also goes a long way. So that it's communication and client management. And we have to make peace with the fact that some clients will not ever understand what you're trying to convey. We have to make peace, with that as well.
We have another question. Again, excellent information. Are there different or additional factors to consider when the prospect is pro bono or referral from a pro bono organization?
If I understand the question correctly, and please let me know if I didn't understand it correctly. When you get a pro bono client, you have to treat that client as a paid client. You don't get to neglect the case because it's pro bono, right? No, you have to treat the pro bono client like a client who pays you. There's no difference. So I don't know if that answers the question.
So we'll wait to hear if that person wants
Mhm.
to type in a response. In the meantime, somebody asked, will you send out the slides? The slides would be helpful for review.
Yes.
We will. Yep. One. Yep. Go
Mhm.
ahead. Sorry, Liz.
Before we move on, so on
Yeah.
that last question, so of course, if you're doing the case pro bono and you're not charging, under Rule 1.5, you're not required to have a fee agreement. You're not charging, right? But it's always good to have something in writing that explains the scope of services,
Mhm.
even if they're pro bono, so that the client understands, hey, listen, this is what I'm going to do for you. And this is not what what I'm going to do and what I'm not going to do. That, in other words, it's beyond the scope of my representation. So that's kind of a distinction that I can think of.
Mhm. And that person, by the way, did respond in response to your response. Yes, it does. So thank you. They felt that you did answer the
Yeah.
question. And then also for those that want to know, this is being recorded. And since you registered, you will receive the link to the recording. You will receive the slides. And we will then post the recording, the presentation on our digital library. So if a friend wanted to review it, you recommended it, they can go to our digital library and it should be there in a few days. But yes, it is recorded and you will get a copy of that recording. So it's great to know that people are interested in reviewing those slides. So thank you for that. I am looking, I don't seem to see any other questions. We do have a few minutes left, but in terms of frivolous, again, I started to ask that earlier. What
Yes.
is it hard? I mean, how do you define, I guess, frivolous? And is that going to be dependent on each lawyer? They might, clearly, every lawyer is going to have a little bit of a different opinion on that.
Yes. So that's a yes. I apologize that I missed that part. Thank you for reminding me. So there are some gray areas. There's some things that you say like there's no way, like there's no case here, and those are easy because you can see it like there's no case here, like
Mhm.
period. Those are easy. When you talk about frivolous claims, you have to think about a good faith argument. Can you make a good faith argument? Okay, because there might be, or maybe you're advocating for a change in the law or a change in the case law, the precedent. You can't. That's not frivolous. If you have a good faith argument to proceed, and
Mm,
perhaps with discovery, you might get some information later on. As long as you have a good faith argument, that's you're typically safe with that. So it boils down to having a good faith argument.
good faith argument. That's great. I think a great differentiator there. So again, somebody related to the frivolous claim and how you can help identify the subtlety of the frivolous
Ah,
claim right up front. And if this person says they find it takes an investigation.
yes. Yes. So when you're doing that intake process, you're gathering information, right? Sometimes you ask the client, the prospective client, hey, can you bring me these documents, right? Let's talk about this and gather some information from the client, right? So you're starting already to investigate. And then you have to ask the questions like, okay, I don't have this information now. Is there a way that I can get this through discovery if I file a complaint, right? Is there a likelihood that you can get that with even further investigation through the discovery process? But during the intake, yeah, you're doing an investigation. So ethically, you're required to do some of investigation when trying to determine whether you're going to take the case or not, or whether the case is frivolous or not. Yes, that's absolutely right.
Excellent. Luz, we have just hit the 1 o'clock mark, and I can't thank you enough for such a wonderful presentation. Very clear, coming at this from clearly the ethical side, but also the human compassionate side. So thank you again. We will be sending out a survey. So for any feedback, So we would definitely appreciate it. And also we take suggestions on future presentations. So be sure to include that. Thank you all for joining us, and we will see you next month with a next installment of webinars for busy lawyers.
Thank
Thank
you,
you
Amy.
all.
Thank you, everyone.
Bye-bye.